Court. My name is Thomas Birch from the University of Georgia, appointed by the court to represent Mr. John Walters. Today, one of my third-year students, Ms. Madison Mischik, will present argument on our behalf, and I'll be standing by. Thank you, Your Honors.
Thank you. Ms. Mischik, whenever you're ready, please proceed.
Your Honors, and may it please the court, my name is Madison Mischik, and I represent John Walters. After Mr. Walters' arrest, he and his assigned counsel, Thomas Stanley, had no substantive communication for 7 months. When Mr. Stanley finally met with Mr. Walters in July 2012, he revealed an expired plea offer from March of that year that would have cut Mr. Walters' ultimate sentence by more than half. Mr. Walters later filed a habeas petition arguing that Stanley's pervasive failure to communicate, including his failure to relay the March plea offer, deprived him of effective counsel. But the state habeas courts and later the district court found that Mr. Walters did not show prejudice because he did not immediately try to accept the offer when it was finally relayed. Those decisions were incorrect for 2 reasons. First, they were inconsistent with Missouri versus Fry and Strickland versus Washington. Second, they were based on an unreasonable determination of the facts. Now, the Supreme Court in Fry said that there was a reasonable probability that Mr. Fry would have accepted an earlier undisclosed plea offer in that case because he ultimately pleaded guilty to a more serious charge with no promise of a sentencing recommendation. And that's essentially what happened here. The plea offer that Mr. Walters ultimately agreed to in January 2013 was significantly less favorable than the one he could have received in March 2012. Most notably, the March offer would have carried a 20-year sentence, whereas the one he ultimately agreed to left discretion over sentencing to the court.
So you would agree?
Well, counsel, that often happens when an initial plea offer is not accepted. And our case of Moschbacher says that subsequent commentary by the defendant is self-serving and usually not worth very much credibility. And apparently the state PCR court didn't find it credible at all.
Mm-hmm. Well, of course, that is true that Merzbacher said that the testimony needs to be deemed credible. Something needs to be present to bolster that testimony. But in Fry, that ultimate acceptance of a lesser deal was the thing that deemed the testimony credible.
But in this case, you have an actual factual finding that the petitioner changed his mind. He came to a reality that the case was more serious than he had thought at the time he was given the first offer, or at that time first offer was extended, and laid out some facts for saying so. I mean, there's some interchanges. He made a pro se offer to the government, and he essentially was found to have turned down an interim offer at 28 months, 280 months. How many months was it? What was the interim offer?
28
years.
28 years, excuse me, 28 years. The first one was 20 years, and the second one was 28. And the state court found he turned that down. And he also turned down the offer to try to reopen the first one. So all these facts are in the record, and the state court looked at those and made a finding that we don't have the Fry situation. So how do you handle all that? I mean, we're not really allowed, are we, to look behind those facts? We just have to determine whether it was reasonable to make the conclusion, even if we weren't to agree.
Yeah, so a couple of things. So first, again, the crucial Fry dispositive factor.
Well, why don't you address the facts of this case? We know Fry pretty well. And why don't you focus on, we're basically reviewing, determining whether the state PCR court was acted off the reservation, so to speak.
Okay. Yeah, so first, and it's just another point that I wanted to make, that the state habeas court should have considered Mr. Stanley's failure in context of his broader failures under both Strickland and Fry, right? Strickland asked courts to consider first the fundamental fairness of the proceedings rather than applying the prejudice standard in a mechanical fashion. And similarly, Fry asks what a defendant would have done assuming he received competent counsel. So we need to look at Mr. Walters' responses in the context of the counsel he was receiving, right?
Well,
and
the difficulty you have here is that the state PCR court made a finding not just with respect to one actor, but with respect to two. As far as the prejudice was concerned, the PCR court said that not only was Mr. Walters not prepared to accept the plea offer, but this state judge was not prepared to have his or her hands tied. And he said, the state trial judge was pretty emphatic and said, I would never accept something that had a maximum of 20 years. Mm-hmm. And the state circuit court, he went down the petitioner's prior convictions and sentences, and he said that none of that had helped him conform his conduct to the law. And he went over the seriousness of the present offense, and then he concludes there's little reason to believe that the court would have accepted a plea agreement that was binding on its discretion for a term of only 20 years. So you've got a finding made both with respect to Mr. Walters and with respect to the state trial judge who's in charge of accepting the plea. And so you're in double difficulty as far as proving prejudice here. Because if the state trial judge wasn't going to accept any kind of 20-year plea, and if Mr. Walters was going to wasn't going to accept the plea deal, how can we say that these factual findings were wrong or?
Well, sorry. Yeah, there were two issues with the court's conclusion regarding the trial court's likelihood of accepting the plea offer based on what the court did a year later when Mr. Walters was ultimately sentenced. And the first is that Strickland specifically says that prejudice determinations should not depend on the idiosyncrasies of a particular decision maker, such as unusual propensities towards harshness or leniency. And that takes on additional relevance here because when the plea offer was extended in March 2012, no judge had been assigned to Mr. Walters' case. So it would be unreasonable to conclude that there's no reasonable probability that a court would have accepted the offer in March 2012 based on what happened a year later. When we don't know whether it would have been the same judge, and we don't know.
But the question is whether there's actual prejudice, and you've got a state trial judge who was in charge of accepting the plea. Said, I would never accept a 20-year maximum for what he did, and it is important to remember. Sometimes we get away from it, but just how brutal this crime was. He got mad at his girlfriend over something and just brutalized her and raped her and all of the rest. And you've got a brutal crime combined with a very unfavorable criminal history and an unwillingness to take advantage of the past opportunities that were offered him to reform his conduct. That's a lot to overlook.
Correct. But, the issue is that we do know that the state was aware of all of this information, all of it's true. The state was aware of that in March and still extended a 20-year offer. So at least the state thought there was a reasonable probability that a court would have accepted the offer.
But it
And
was
again-
not binding on, this was not a plea that was binding on the
Correct.
judge if he didn't want to accept it.
Mhm. Yes, that's true, but I think it's unlikely that the state would extend an offer that it didn't think a court would be willing to
Well, the
accept.
state is only one party to it. Mr. Walters, even in August of 2012, when Mr. Stanley offered to put the March plea deal back on the table, Mr. Walters said no, because during this entire time, as you're well aware, he felt he was a victim, oddly enough, because he thought his girlfriend had cheated on him, and that he was the victim of everything, and that he deserved leniency and didn't deserve any incarceration time, or at a minimum, very little.
Mhm.
And he somehow, I don't know how he arrived at this conclusion, he somehow thought that his actions were justified and that he was the victim, and there was no way he was going to accept 20 years where he felt he'd been wrong. Perversely felt he had been wrong.
Well, again, I think going back to Fry, if we're looking at Mr. Walters' behavior in the context of the counsel he was receiving, at the time he was either receiving, no or very little counsel from Mr. Stanley. Mr. Stanley hadn't given him a lot of advice, hadn't given him a reason to trust him. But
I'm not suggesting that Mr. Stanley acted appropriately. In fact, I don't think he did. I think the performance prong was not satisfied. It all comes down to prejudice. But again, in August 2012, there was a communication. Mr. Stanley offered to put the March plea deal back on the table, and Mr. Walters said no dice. And it's just a tough thing to overcome, because it's a hard case given the fact that these findings of prejudice are factual in nature.
Well, again, looking at Fry asks, as I said, what a defendant would have done had he received effective counsel. And Mr. Walters did eventually receive effective counsel, right, in September 2012. And at that point, he stopped requesting leniency and he started to negotiate a new plea agreement. So if we focus on what he did with effective counsel versus what he did with an ineffective counsel, we see that he stopped, asking for mercy, asking for leniency, and didn't negotiate that plea agreement. And I want to address another issue with the court's conclusion that the trial court would not have accepted the offer. As I said, that one issue is that we don't know whether it would have been the same judge, but the other issue is that the state courts failed to acknowledge how circumstances changed between March 2012 and March 2013 and how that could have changed the judge's opinion of Mr. Walters. Right. For one thing, the state implemented that 43 to 65 year sentence the court did after the state actively lobbied for it. But had Mr. Walters been able to accept the March offer, the state would have been lobbying for a 20-year sentence. And there's a good chance that the court would have given that recommendation at least some weight.
You may be right in that. A time from March to December is a lot of time, and a lot of things could happen. But don't you have the burden of showing that the PCR court was wrong in the conclusions it reached? I mean, its conclusions weren't unreasonable. You disagree with them, and you make a case for it. You've laid out the case, but I'm wondering. We're a federal court. Being asked to review a state court process, and essentially at the foundation, we're to stay out of it unless we really have an ability, or whether we see something that really violates the federal Constitution. And in this case, that burden lies on you. And the trouble is, you have these findings by the PCR court, which we're essentially told to leave alone unless they're really off the charts. And so you've made that case, but how do we say the state PCR court was unreasonable?
Right. And I see I'm out of time. Can I answer that question?
Yeah, go ahead.
Please,
Yeah.
yes, you certainly may.
Yeah.
Please proceed.
Yes. Yeah, so I think the real issue here is sort of the standard that's outlined in Fry of, a reasonable probability. Mr. Walters needs to show a reasonable probability that the court would have accepted the offer, right? That's not a terribly high standard. He doesn't have to prove that it definitely would have. And I think, when you look at the fact that we don't know whether it would have been the same judge, it could have been a different judge. We don't know what a different judge may have thought about Mr. Walters.
I'm not sure why we wouldn't, in looking at prejudice, look at it a historical matter and take as a given that it was assigned to the judge who expressed the reservations that he did. It's not a hypothetical universe of judges. I wouldn't think. I think when you're looking at, was there prejudice in this case, you're looking at it as a historical matter, and you're saying, no, it would have come before this judge. And he was just emphatic.
Mm-hmm. Mm-hmm.
And at any rate, you have some rebuttal time, and if my colleagues have any questions of you, I'm perfectly willing to wait until they've responded. Judge Niemeyer, do you have any further questions?
I'm ready to go on to hear the other side, and then we'll hear her.
Judge Agee?
So am I.
All right. Well, we thank you, Ms. Mitchell, and we look forward to hearing from you in rebuttal.
Thank you.
Mr. Williams, when you're ready, let's hear from your side of it.
Well, thank you, Your Honors, and may it please the court. In this case, the state habeas court had to resolve a fact-intensive hypothetical, namely, what would have happened if petitioner had been told about the state's early plea offer? This counterfactual required the state court to parse multiple competing pieces of evidence going to petitioner's particular state of mind at a given point in time, and the trial court's later willingness to impose a substantially lower sentence than the one it ultimately imposed. That analysis, as the court seems to recognize this morning, required credibility assessments at essentially every step of the way. The petitioner would like this court to tackle that counterfactual anew, offering all manner of facts that, in his view, the state court should have given more credit to. But in the end—
Let me ask you a question, Mr. Williams.
Certainly.
In assessing prejudice, should we assess the fact that this might have been assigned to any member of a universe of judges, and sort of take the fact that if there's even one that would have sentenced him to a more lenient thing, that weighs in favor of finding prejudice? Or should we look at it simply as a historical matter and look at the fact that, as a matter of historical fact, it was assigned to this judge, and this judge said, no way am I going to limit myself to a 20-year maximum sentence. And so historically, as a matter of fact of what happened here, there was no prejudice.
I think it's the latter, Your Honor, and you could look at that for a couple of reasons. One is, it's just as you said, it's what happened. We don't have to blind ourselves to what actually happened in the assignment that was eventually made. But even if you want to try and speculate that this could have been assigned to another judge within the circuit court, what this judge did in this case is a very good indication of what an objective, reasonable jurist would have done.
I'm saying the same thing would apply under Strickland to juries.
Right.
We can't say, well, he went to a jury trial, and there may have been some hypothetical jury out there that would have ruled in his favor. You have to take the juries, the actual jury that heard the case. And if that's true with juries, you seem that we would have to do the same thing with a trial judge. In other words, I'm thinking, you can't just speculate as to another judge or another jury or whatever. You have to talk about that judge and that jury in assessing prejudice.
I think that's exactly right, Your Honor, because otherwise all the court's left with is speculation. And I think, indeed, this case shows the danger of that speculation, because petitioner's argument seems to be that this particular trial judge was idiosyncratically harsh. But in reality, when you read the transcript, the trial judge was justifiably outraged at the nature of these facts, and it said that a recidivist enhancement could have been justified and probably should have been.
Mr. Williams, is it necessary even to address the second part of the Fry test? I mean, here, as if I'm remembering the record correctly, the West Virginia Supreme Court only addressed the first prong, as did the magistrate judge and the district court. So unless the defendant is able to show by clear and convincing evidence that there was an unreasonable determination on the first prong, which was that Mr. Walters would have accepted the guilty plea, which the state PCR court found that he would not, the case is over, isn't it?
That's absolutely correct. These are two separate independent prongs. The court sees that in both Fry itself and the way that Fry was applied by this court in Merzbacher. So the court could just as easily decide on that first prong, and indeed it should. There's substantial reasonable evidence upon which the state habeas court could have relied to find that this petitioner would not have accepted the lower plea when it was offered earlier in 2012. And you've heard some of it discussed already this morning. Some of those include the letters pleading for mercy, the letters suggesting that he wanted to get out right away. There was extensive discussion about his young son and how he thought he should be present in his young son's life. This was clearly a petitioner who was not coming to grips with the reality of the situation and the combination of both the heinous facts of the crime that was at issue and his substantial criminal history. And so any of those facts would have been a reasonable basis for the state habeas court to rule as it did. And we have to keep in mind, it's easy to sort of blow past those AEDPA standards because they're frankly so headache inducing sometimes. But the standard is really whether any fair-minded jurist could have ruled as they did. And the state habeas court, the Supreme Court, the magistrate judge, the district court all agreed that there were more than reasonable bases to determine that at the point in time in which this decision was presented to him, that this petitioner was simply not willing to come to grips with the nature of his potential sentence. And
you've got to admit, Mr. Williams, that Mr. Stanley did not cover himself with glory in his representation of Mr. Walters in this case. I mean, it's it flatly failed the performance prong, but the Supreme Court has encouraged us to pick up prejudice first and to go directly to prejudice without talking about performance. But it just is worth remarking that the lawyer's performance here did leave a great deal to be desired. I gather you would agree with that?
I agree, Your Honor. I think, again, this is similar to Merzbacher in that there is substantial reason to question what was done here and the facts that unwound on the deficient side. But ultimately, as in Merzbacher, there's simply no reason to make a finding as to the deficient, the failure to meet standards of professional conduct, because the prejudice prong is really what decides this case. And the prejudice prong is unfortunately for petitioner a losing argument for two separate.
Well, we've been encouraged to take up the issue of prejudice first.
Correct. That's right. And I think it's especially easy and especially appropriate for the court to do so in the state habeas context, given the standards of deference that are owed to the findings of the state court. The Supreme Court has said this is a substantially high standard, and it's a very difficult standard to meet because it was, quote, meant to be. And so for a petitioner to come here and sort of put their own gloss on facts simply isn't enough. And as Merzbacher again reiterates, it's all well and good to say that a petitioner might be able to tell a story in which they potentially maybe could have suffered prejudice. But so long as the state court had a reasonable basis upon which to find otherwise, and so long as a reasonable jurist could have found otherwise, then this court has simply no discretion to do anything other than to affirm that decision. So, Your Honors, we really do think that this is a decision that's driven by those AEDPA deference standards, that this really is kind of the unexceptional state habeas case in that way. That given the substantial evidence that was in this record, to permit the state habeas court to conclude, as it did, that this is a petitioner who was not willing to accept early in 2012 the plea that it was presented, it simply isn't a reversible decision, and the district court correctly determined that a writ was not issued here, or should not issue here.
What's your response to the petitioner's suggestion that the deficiency in performance actually implicates our analysis on prejudice, insofar as she argues that he could have been talked into accepting the plea and maybe persuade the court to accept the plea if he had good counsel. I think that's what she's arguing in essence in one aspect.
That's how I understand the argument as well, Your Honor, and respectfully, I think it errs both as a matter of fact and as a matter of law. As a matter of fact, this is a petitioner who fought every step of the way early on to any suggestion he was going to face any substantial prison sentence. Was, in fact, although petitioner now puts the spin on it that the professional relationship between counsel and the petitioner broke down because of the early absence of the lawyer from the case. What a lot of the evidence actually suggests is that the professional relationship broke down because the lawyer was pushing petitioner too hard to face the reality of his situation and trying to get him to understand, sometimes in frankly very coarse terms, that he was in a very bad situation, that a jury would not find him credible, that given his intent not to testify, he really had no way of mounting a defense. And even given the attorney's very emphatic insistence that these facts are terrible for him, the petitioner continued to insist on moving forward. And again, some of the correspondence that petitioner himself issued to both the court and the prosecution's office provide a contemporaneous insight into the nature of his thinking over the entire course of this discussion, both early on and then well into July and August. And he's continuing to maintain that he's an innocent actor.
Mr. Williams, if you could reflect on it in this light, and I meant to ask opposing counsel this, so perhaps she can answer it as well when she's up.
Sure.
Under the Supreme Court of West Virginia's order, it said that Mr. Walters' sole ground was the ineffective assistance to trial counsel for failing to provide him the March 9, 2012 plea offer. And that's the same issue that appeared in the magistrate judge's report, the district court's report, and it's what the certificate of appealability was granted on in this case. Now, petitioner asked to expand the certificate of appealability to say that prejudice should be presumed because of counsel's pervasive failure to communicate. That request was denied. So it strikes me that some of the argument there is on an issue the court has already determined we would not hear.
That's exactly right, Judge Agee, and you actually anticipated the second part of my answer, which is the legal part of the answer. As a legal part, this claim was not, this sort of cumulative error claim was not presented in either the state court petition or the federal court petition. Although they alleged the argument was made below, they're referring to certain briefs in support of certain arguments that were made in the district court. They did not amend their petition below to state those claims. They then come here with a constrained certificate of appealability. They, as you just noted, tried to move to expand their certificate, and the court denied that request, said that they could not mount a claim under chronic. And then the court's decision in Fisher says that they couldn't in any event try and make a sort of cumulative error claim on an ineffective assistance anyway, that the court, if the court were going to consider these other claimed instances of deficiency, that it has to consider them as discrete actions and then undertake the Strickland analysis for each individual discrete action. So for at least three separate reasons, even if you put aside the specific facts of this case, there wouldn't be a legal basis for the court to consider those sort of cumulative error ephemeral arguments from petitioner anyway. So that's exactly right, Your Honor.
Mr. Williams, do you have anything further?
No, Your Honor, I think the state would be content if the court has no further questions to rest on their brief, and we would respectfully ask that you affirm the decision of the district court to decline to issue the writ.
Judge Niemeyer, Judge Agee, do you have anything further to ask Mr. Williams before we hear in rebuttal?
I'm fine, thank you.
And nothing further.
All
Thank
right,
you, Your Honor.
counsel, thank you, Mr. Williams. Counsel, let's hear from you in rebuttal, all right?
Okay. Thank you, Your Honors. I'd first like to address the matter you're just discussing about Fisher in particular and considering multiple errors cumulatively. And we would distinguish this case from Fisher because in Fisher, the issue was considering individual actions that were not individually errors, and the court declined to say, cumulatively those resulted in harm. And that's not what we're doing here. We're really asking the court to do what Strickland and Fry asked the court to do, which is to consider sort of the broader circumstances when evaluating prejudice. We don't need a chronic claim to do that because Strickland, talks about the fundamental fairness, talks about evaluating all the circumstances. And again, Fry asks to look at what a defendant would have done had he received effective counsel.
Let me ask you this: the judicial system is hierarchical, and we are under, seems to me, a special obligation to follow the decisions of the Supreme Court. And you read a decision like Harrington v. Richter, for example, and it just goes on and stressing how deferential we are supposed to be. And there's also a string of per curiam reversals of circuit courts that have tried to unduly interfere, particularly with state PCR court fact-finding. So what do you do with that strong institutional interest that we have and the very stern guidance backed up by per curiam reversals when we stray beyond our proper role? I mean, are we just supposed to sort of throw those restraints overboard? I mean, that seems to me where we would be headed, given the fact that there was a clarity to the state court fact-finding.
We are not asking this court to do that. We are wanting to focus on what Fry and Strickland tell the state habeas courts to do when evaluating prejudice, which is, especially in a case like Mr. Walters and like the situation in Fry, is to focus on the later acceptance of the lesser offer to bolster the credibility of the defendant's statement that he would have accepted the earlier offer, right?
But when at the end of the day, it is a factual determination, is it not?
Yes, it is. But the fact that he later accepted the lesser offer, we know that doesn't require a credibility finding. That we know that we of course realize that the state did make a credibility finding, and we're not disputing that necessarily, but that fact, that crucial
But
fact,
doesn't that fact, that's a stream of logic that follows. And Fry talked about that. In other words, if you later accept a higher sentence, it's sort of indicative of the fact that you would have accepted a lower one had you had it. But that logic seems to be interrupted by the second offer in this case. How do you handle that? He was specifically asked, and the court found as a fact that he was offered, number one, to make an attempt to reopen the March offer, and number two, to consider the 28-year offer. And the court said he rejected both.
and again, I think that goes to the Fry focus on considering what this in the context of the counsel he was receiving, right? As I said, he'd spent 7 months trying and failing to get Mr. Stanley to help him. He didn't trust Stanley's advice. He knew that Stanley had allowed a favorable offer.
You're focusing on the facts and as if we were a fact finder.
Right.
My question is, we have a state court ruling that he rejected those and also laid the foundation for those rejections, that he basically was not inclined to accept any offer at that point. He thought he was innocent, and he thought that he had reasons for not accepting any plea at that point. And it's not whether that's right or wrong. It's how do you address the fact that we have the finding? In other words, the only thing you can say is that finding is just totally unreasonable, isn't it?
No, I wouldn't say that. Again, I think we need to focus on what Fry says, which is, had he been afforded counsel, effective counsel, what he would have done.
No, you're missing my question. I'm not arguing. What I'm arguing is you constantly ask us to consider facts, and that's legitimate if you're making an argument that the state court was off the charts, but the state court made the finding. We don't need to look at the facts except to determine, did the state court act reasonably in making those findings? And it sounds to me the state court was very reasoned. They laid out each step as to why they reached a conclusion. They had evidence in the record to reach it. You would probably disagree on that fact finding. If you were the judge, you might have gone the other way. But we have this finding, and it's hard to come to grips with that, but I think that's our role at this point in time, isn't it?
Well, I think the issue with that is that, the state courts did have obviously the prerogative to make their factual findings, but they needed to do that within the constraints of the law. And the law says to consider in the context of the counsel he was receiving. And by putting a lot of emphasis on what he did when he wasn't receiving effective counsel and discounting what he did when he did receive counsel was misapplying the law. And another issue I would add with that is that the state Supreme Court mistakenly said that one of Mr. Walters' requests for leniency was sent in August. It was actually sent in November. And that's a really significant error because, as I said, he didn't have effective counsel in August, but he did in November. So that—
Let me just ask you a factual question. To the degree that Mr. Walters had a change of heart, did that change of heart not come until after the indictment?
So when he
said, well, I might have accepted this plea after all.
Well, I mean, I suppose the indictment was in June, so I don't think we have— he didn't know about—
All I'm suggesting is that we have a lot of cases where people, the closer they get to trial, particularly after an indictment, the more nervous they become. And sometimes they often have a change of heart, but the change of heart comes too late because the plea offer has expired. Mm-hmm. But I'm not sure that, just as a general matter, I'm not sure that any 11th hour change of heart implicates the unwillingness to accept the plea during the period before its expiration. You see what I mean? They're just people that the trial date puts a real apprehension into a criminal defendant, and it often induces a change of heart, but I don't think it doesn't affect the prejudice analysis, which is, what was his state of mind prior to those expiration dates.
Right. So I think about the trial date, then a really important fact is that in Fry, the defendant, Mr. Fry, didn't plead guilty until I think 8 days before trial, and that wasn't important to the court. The court said he accepted the lesser offer. He pled guilty to the more serious charge, and that's what mattered. And then I think with regards to the indictment, that happened in June, I believe, and Mr. Walters had not received any advice from his attorney. I think he'd spoken to him only once, right? And so again, going back to Fry, looking at it in the context of what a properly advised defendant would do, is it right to penalize Mr. Walters for not having any counsel during that period?
Right. Thank you. Thank you very much for giving you a little bit of extra time here. And unless my fine colleagues have additional questions, I'm going to wrap things up. But before doing so, Mr. Williams, I know you're probably here under circumstances that maybe you didn't expect, and I want to just express the appreciation of the court for the very fine argument that you've made. And Ms. Mitchick, I think you've made a very fine argument, and you've honed in on the Fry case, which is exactly what you should have done. And I think it was an exceptionally fine argument, and we're always really happy to have student counsel appear before us. And if you ever want to go into the practice of appellate law, I think there's a very promising path ahead. So thank you so much.
Thank you.
Thank you both so much. We can't shake hands with personally, and I hope you understand that we hope the day will come when we can. All right, let's move into our next case.
Jones for the elements. And so the way the Virginia Court of Appeals lays out the elements in the Jones case is that they give element 2 as drives in willful and wanton disregard of the signal, and 3 as drives in a way that interferes with or endangers, showing that that final element does not have a mens rea requirement. And this is actually
the same Virginia Court of Appeals en banc in Bazemore recited the instructions with the elements, and it recited the instruction willfully and wantonly disregarded such a signal so as to endanger any person, etc. So in that case, the en banc Court of Appeals had it all as one element.
That's correct, Judge Agee, but our argument doesn't depend on the fact that it's separated out into 2 versus 3 elements based on our.
What difference does that make if the elements read on to each other? In other words, the willful and wanting disregard is limited to a circumstance, so as to is a limiting clause to the language that follows. And the language that follows is a physical endangerment type of language.
That's correct. And so as to means with the effect of. And so,
yeah, sure, that's good enough. But so as to are good words too. We can use those. Those are good English
yes,
words.
Yes, that is the wording the statute uses. We're not arguing that isn't the consequence of the willful and wanton disregard, merely that there's no mens rea attached to this consequence.
But they added that language, they added that language in order to narrow the number of individuals who could be charged with this. They added the affirmative defense, which is not an element, but it's still a defense. And then they added the endangerment language, which was the very purpose of that was to say that this statute is going to be directed at a particularly egregious disregard of a law enforcement signal, not just any old disregard, because there may be innocent explanations or there may be all kinds of extenuating circumstances, but this kind of thing where there's a disregard and an endangerment, they want to limit it to the more serious offenses. And that would seem to me a very responsible thing to do in terms of giving criminal defendants fair treatment and not just having the ordinary case where they just disregard, not having that fall into this hit and runs, into this felony eluding statute.
Yeah, that actually goes to our other arguments for why the offense is not a CIMT. And with regard to endangerment, someone can be found to have endangered if they raise a mere specter of endangerment to themselves and no one else. The Court of Appeals of the Virginia Appellate Courts have recognized that the defendant counts within the definition of a person and that a mere specter of endangerment is enough. And this is a really low standard, one that does not require imminent.
Do you think they're trying to legislate against the protagonist in this? The defendant has disregarded a siren. He's trying to flee the officer. He's in an automobile, a moving automobile. He's trying to get away from the officer. The officer's trying to get to him. And as a result, he interferes or endangers a person. Now, do you think the legislature is seeking to protect that man under the clause endanger a person? I mean, he may be included in that class, but they're clearly talking about the conduct that's going on that poses a high risk of injury or death or accidents or property damage of all kinds. And same with the interference. The interference doesn't occur as if somebody was just misleading somebody. The interference here, they're talking about two moving vehicles, one trying to get away from the other and purposefully disregarding the light. This whole context that is being addressed is fraught with danger. And to make it even more clear, the legislature says we're excluding negligence. We're intending the more serious conduct because negligence is affirmative defense. So I don't know where you want to lead. Are you saying the word person is so broad that it includes the guy fleeing, and that statute is intended to protect the guy fleeing? Is that the interpretation you want to give?
We are not focused on the intent of the statute, but rather what the minimum conduct is.
I understand, but the minimum conduct has to be something that's rational, that's applied, and it has to be the core. I mean, the fringes, the Supreme Court's always excluded the fringes in the.
Sure, Your Honor.
But answer my question. Do you think this statute can reasonably be read to be protecting the fleeing defendant?
Yes, and that is how the Virginia Supreme Court ruled in the Phelps decision. By ruling in that case where the defendant only endangered himself, and that's the finding that the court upheld on appeal, the defendant only endangered himself, and yet they upheld their conviction.
Well, then that answers that question anyway. If you interpret it that way, the Supreme Court of Virginia has said that's an endangerment of a person, which is would fall into the moral turpitude notion.
Well, Your Honor, I see I'm out of time, but may I respond briefly?
Sure. If it's okay with the chief, yes, sir. Yes, ma'am.
Absolutely.
Sure. And so our argument is that by merely raising a specter of endangerment to the defendant himself, that is not a crime, that does not involve reprehensible conduct, especially given how low of a standard a specter of endangerment is. Again, there's no need for imminent risk, and there's no requirement that the risk be a risk of serious bodily harm. And in terms of what this looks like in terms of examples, I do want to direct this court to page 343 of our joint appendix, and where we have the affidavit from the former Virginia prosecutor, in which he says that he successfully prosecuted defendants for eluding police by just speeding, and they were convicted even though the defendant endangered only himself. There was no one else on the road, and the police themselves were not endangered.
Well, what do you do with our Tillery decision and came down in 2012, where it says that this court has ruled that the Virginia felony eluding requires intentional conduct and is thus a crime of violence? That would indicate that the statute was aimed at particularly serious conduct and consequences.
Sure. So the analysis for the crime of violence and a CIMT is different in that crime of violence looked at the typical case for an offense and whether that typical case raised a sufficient degree of risk. Whereas for a CIMT, we are again focused on minimum conduct. And just because an offense poses a significant degree of risk doesn't mean it's necessarily a CIMT. For example, we have various driving offenses that are dangerous, like DUI, reckless driving, that are not CIMTs. And this court has further found that extremely dangerous offenses, like offenses that have led to death, such as involuntary manslaughter, are not CIMTs. With regard to Tillery, this court in Tillery did not evaluate the mens rea for felony eluding. And that's because they were focused only on the degree of risk that Virginia felony eluding posed, right. And they never got into, and this court okay, thank you.
Thank you very much, but you also have some time for rebuttal, and we'll look forward to hearing from you then, okay?
Thanks, Your Honor.
Ms. Freyer.
Good morning, Your Honors, and may it please the court, Allison Freyer for the Attorney General. Felony eluding is categorically a crime involving moral turpitude, or CIMT, because it has a sufficiently culpable mens rea and sufficiently culpable conduct. First, with regard to the mens rea, the willful and wanton disregard of the signal so as to endanger or interfere. As Your Honors were pointing out earlier, the so as to language is linking language. It links the disregard of the signal to the manner in which the defendant must drive to be convicted. And the endangerment or the interference component is precisely.
It's both linking. It's the interesting thing about that language is it's both linkage language and it's limiting language. So it not only links the disregard to the endangerment, but it limits it to endangerment cases, which would prevent the misuse of the statute. So it seems to me you have a particularly strong case where you have language that's both linkage language and limiting language. That means you are isolating a particular class of severely culpable offenders who demonstrate a really the highest level of intentionality and mens rea with willful or wanton, and the worst possible way in which the conduct brings about its results. And you step back for a minute and say, is this the kind of thing that Congress would regard as a CIMT with multiple of moral turpitude? And it seems to me the answer to that was so clear that how could Congress regard this as anything other than a crime of involving moral turpitude? I mean, the whole thing, the way in which the Virginia law is written, Congress's desire in the immigration laws and everything, it all links up.
Yes, the government would agree. Not only is the language linking, but it limits the statute to extremely serious cases. It indicates that Virginia felony eluding is an incredibly serious crime, and even the minimum culpable conduct under the statute poses significant risk to officers and drivers on the road, and is therefore morally reprehensible. And this is exactly the sort of thing that Congress had in mind in crafting the phrase involving moral turpitude. The Virginia courts have always, all the cases that the parties cite in their briefs are serious cases in which the defendant was being stopped by a police officer. The person knew it was a police officer. They consciously, willfully, recklessly ignored the signal and drove away so as to endanger or interfere. And the facts of the cases really speak for themselves. There's no conviction in which the defendant merely sped a little bit on his way away from the officer, or he ran a single stop sign as he avoided the officer. There's always the arrogant recklessness, the conscious disregard of serious risks that the wanton and willful language describes are present in the driving of the presented in the state cases. And therefore it's clear that Virginia felony eluding is a serious offense that only includes morally reprehensible conduct and does not include mere traffic infractions.
Let me ask you this, would you, what's your take on if you wantonly and willfully disregard an officer, such as to endanger yourself with the risk of injury or death? Is that morally reprehensible?
It is. Petitioner's counsel is correct. That's included in the statute. The Virginia state courts are clear, but it is nevertheless morally reprehensible because the defendant is not choosing.
In other words, all life, whether it's all human life that's put into danger is valuable, and we almost every moral norm aims at the protection of life and some other things, obviously, too, but foundationally. And so your point, I gather, is that if the defendant is a human being, he deserves the same level of concern about societal norms about his own life as well as others. And we try to protect people against harming themselves and causing danger to themselves.
Exactly, especially when that danger may spill over into other people. The defendant in Phelps managed to.
Well, that's another aspect. That's pretty clear. But I think the point being made was that the statute's broad enough to cover endangerment to any life, not just
that's true.
other person's lives. And the question whether that's a moral norm beyond just a statutory stop sign type of norm.
Yes, absolutely. I think that that it still violates a moral norm to put yourself in mortal danger, especially if you may harm others and in the process of doing so. Yes.
Do you have anything further that you wish to add?
No, if the court has no further questions, the government will rest on its briefs.
Judge Niemeyer,
I'm fine, thank you.
Judge Agee?
I'm fine as well.
All right, I'm fine as well. I really want to thank you and appreciate it. And then I want to hear from the petitioner here in rebuttal.
Thank you, Your Honors. I did want to expand more on our final reason for why the offense is not a CIMT. And that's because someone can be convicted if they elude in a way that merely interferes with the operation of the law enforcement vehicle without endangering anyone. And that's from the plain language of the statute. And this type of minimum conduct is actually similar to Virginia obstruction of justice, which this court ruled in Ramirez was not a CIMT.
Well, obstruction of justice involves a lot of things. Obstruction of justice can involve encouraging somebody to not testify, to testify falsely or whatever. But here, the interference has context, has statutory context. And what we have is, number one, we have a defendant who willfully and wantonly violates a signal of a law enforcement officer. We have him trying to flee. He's in an automobile, a moving automobile, because he's refused to stop. The statute uses the word stop. So we assume he's moving. The police officer is moving. And here you have two cars moving in with antagonistic purposes. One's trying to get the other, and the other's trying to catch up. And there's interference in that effort. That's a height of danger. I mean, this is not just the isolated word interference from the dictionary. This is interference of an officer trying to make a stop on a highway, public highway, with respect to a guy who wantonly and willingly disregarded the order of the police officer. I don't understand how, then you might ask, well, why do they use interference and endangerment? Well, one's incipient in that it affects the officer's performance in carrying out his duties there, and endangerment might be actual endangerment. Interference is going to lead to endangerment, but I don't see how you get any real benefit by isolating interference in this case. I don't think you can isolate it.
Sure. Well, the statute uses the word interfere or endanger. And so
I understand, but let's pick interference. Forget the endanger. He's interfering with the police officer's operation during the course of this crime, right?
Sure. Yes.
Okay. And this crime's a moving crime with a lot of physics going on. A lot of potential for danger, injury, damage. These high chase situations are featured regularly on television. Everybody's concerned about where this is going. We're not just talking about obstruction of justice. We're talking about interference in a highly volatile circumstance, which is physical in nature.
Sure, Your Honor, and I see I'm out of time, but may I
briefly answer the question? Of course, I'm interested in hearing your response. Yeah.
Yeah, so we are focused again on minimum conduct here. And so based on the plain language of the statute, the minimum conduct here is that someone could interfere without endangering. And while there may be small differences between the minimum conduct involved in obstruction of justice and interfering and eluding in a way that merely interferes, the reasoning for Ramirez is actually still on point, which is that any mere attempt to obstruct the government without some kind of aggravating element, such as use of fraud or threats.
How about use of force and violence and automobiles at high speeds?
Well, Your Honor, focus.
Isn't that different from your broad category of just interfering like obstruction of justice?
Well, here we are focused only on interference and assuming that the person doesn't endanger anyone else. And so based on that, that aggravating element is not there. And
Isn't it hard to envision interference without some element of endangerment when you're disregarding a signal? Because when you say disregard a signal of a law enforcement officer, that implies that both cars are moving. Doesn't just imply that one is stationary.
Yes, both cars do have to be moving. But for example, someone could, even if they weren't speeding at high speeds, they could drive off a road into tall grass with the officer in pursuit. And even if there is no danger involved,
how does that interfere with the officer's operation?
Sure.
That's just an effort of fleeing. It seems to me, if you're going to focus on interference, the language of interference, we have to accept what it means. And it means interfering with the officer's effort to stop the other car while the officer's in a car, both moving at high speed, one with a wanton and willful disregard of the officer, and the officer with an intent to make a stop.
Sure, Your Honor, and I will answer briefly because I see I'm out of time. There's no requirement that there has to be high speeds for someone to be convicted of eluding.
It can be a low speed, but it's the question is they're both moving in motor vehicles, and the interference has to interfere with the officer's effort to stop the car and not just driving into a ditch. Now he's caught. The question is the interference component, and it's hard for me to read that in context and not picture incipient endangerment.
In the crime of violence situation, the Supreme Court makes the point in Duenas-Alvarez that we're not to imagine all of these hypothetical situations that could conceivably be possible, that we are to look at the heartland of a statute. And I suppose that it might be possible for a particularly creative person to imagine interference without endangerment, but that kind of, I think the crime of violence warning that was issued in Duenas-Alvarez has applicability here, which is, I just don't think we can take possible imaginary instances on the far, far perimeter of a statute. I think we really have to look at the heartland of what the statute is driving at.
And I will direct this court to its decision in Gordon v. Barr, where this court ruled that where the plain language of the statute is overbroad, the burden doesn't shift to the petitioner to point out a specific case. And so that case is certainly binding on this court. So if the statute is overbroad, there doesn't need to be a specific case or a specific example of prosecution.
Mm-hmm. All right, do you have a brief summation? We've taken a lot of your time with questions for which I'm sorry, but it just goes to show our interest in your case. And I wondered if you had a few brief comments and summation that you wanted to make.
Sure, Your Honor. We also do request that if this court intends to grant the petition for review, that it order petitioner released from custody, given that he's been in detention for almost 2.5 years now. And
all right, well, thank you very much. Thank you both. As I said at the previous, we very much regret that we can't perform our traditional Fourth Circuit greeting, and thank you for the able assistance that you've given the court. But there will come a time when our traditional greeting will return, and I hope that each of you will be present. We'll be able to thank you in person. So I appreciate it, and I'll ask the courtroom deputy to adjourn court and move us into the conferencing room.
Thank you, Your Honor.
Thanks, Your Honors.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I'm going to move you into the